Right, welcome back. Now, this week, two of South Africa's court cases have drawn huge public and legal interest, and they continued in the High Court in Pretoria and at the Bloemfontein High Court, respectively. Now, after several postponements and controversy, the trial against 5 men accused of shooting and killing Orlando Pirates and Bafana goalkeeper Senzo Meyiwa in 2014 has resumed. And the High Court in Pretoria is hearing testimony from the state's fourth witness, Mthokozisi Thwala. And to give us some analysis on this trial and some of the other developments in other trials, the Thabo Bester escape and other stories as well, we are joined by the criminal law expert, Zola Majavu. Mr. Majavu, good to have you with us. Welcome to Morning Live.
Good morning, Sis Kati, and good morning to the viewers out there.
So before we take a look at what's happened this week, because there's been quite a lot going on, let's just first talk about former President Jacob Zuma's bid to take his successor as President Ramaphosa to court over Ramaphosa's appointment of Chief Justice Raymond Zondo. So what do you make of this? What's your opinion on the demand that has been made, and how is this likely to play out?
Sakina, firstly, I think as a starting point, one always appreciates and respects the rights of any citizens or any constitutional subject to use the courts to vindicate whatever rights or positions they may adopt. So there is absolutely nothing wrong with this intended move by President Zuma. However, I've had occasion to look at the letter written on his behalf by his attorneys. And they make fundamentally two demands. Firstly, they demand of President Ramaphosa to reverse what they regard as his irrational and illegal decision to appoint Chief President Chief Justice Zondo. My apologies. The second one, they demand reasons that animated the president's decision in making that appointment contrary to the recommendations of the JSC. Now, I would have thought that perhaps a useful starting point would have been to demand reasons first and look at the reasons to determine the rationality which they are complaining about. And having perused those reasons, then maybe they could then consider a possible review to challenge that president's decision. But they have couched their demand in the order that I have stated. One, demanding a reversal of the appointment, and secondly, the reasons. I think it is something that would be adjudicated upon in the fullness of time by a competent court, probably in the form of a review application. But standing where I am and having looked at the process, on their own admission in the letter, they make concession that the correct processes were followed. However, they seem to be suggesting that the president was obliged to accept the recommendation of the JSC in the manner in which it was made, and that is clearly incorrect. It was a recommendation. There's a difference between making an appointment in consultation with or after consultation with. In this instance, the president duly considered the recommendations and he made his decision, and there can be no suggestion that he was legally not obliged to act in the manner that he did. However, in the absence of the full reasons that would support this application, it's still early days for one to even preempt how it might unfold. But we can definitely accept that this is a matter that may well end up in the same concord in which Judge Zondo is presiding. He is, after all, the Chief Justice in the Republic of South Africa. But obviously, if the matter were to go before that court, he would almost inevitably recuse himself. So it's still early days. I think one would be in a better position to shed better light or guidance once the reasons have been given and possibly shared with the public. But in principle, there's nothing wrong with that application. Whether or not one believes it's meritorious, I have my doubts, but I have to respect that the legal team and the former president may know something that one is not necessarily privy to. But it is something that is going to play itself out in the courts over a long period of time.
And of course, we'll wait to see how that unfolds. And then also, Mr. Majavu, there was another interesting case this week. And, the first state capture case, so to speak, to come before the Free State High Court, the Nulani Investments case, and the judgment handed down there was perhaps a bit of a blow to the NPA's investigative directorate because this was a loss for them, and it's drawn quite a bit of criticism from the general public.
I would agree that it's not a good showing for the NPA, especially for a case of this magnitude, and given the fact that it was happening for the first time. But it is what it is. The courts of the land have pronounced themselves on the matter, and we've got to respect it. And it is not a decision that is appealable, by the way. The NPA, if aggrieved by it, they would have only been able to appeal on points of law. But here, it was an outright discharge in terms of Section 174. What is most interesting is that this acquittal came by way of a discharge even before the accused were put on the stand to say their side of the story. In terms of our legal system, it is permissible if at the end of the state's case, there is no basis on which a reasonable person would convict the accused persons other than if they entered the witness box and incriminated themselves. So it is quite a blow. I cannot imagine that the NPA is quite happy with it, but they have no choice but to respect the decision of the court, which I know they have said they do.
So that, of course, raises another concern, and this speaks to the capacity of the NPA and, of course, the investigative directorate. And we would remember that the former head of that directorate, Hermione Cronje, of course, resigning from it, and there was quite a bit of buzz and talk around that particular development at the time. And now we see, this particular judgment being handed down, and people are concerned, I think, also, Mr. Majavu, about the state's ability and capacity then to deal with other state capture cases that may come before them.
Well, I can understand that, but I think in fairness to the NPA and the investigative directorate, we should not generalize. This should not be seen as a scene setting or a tone setting precedent, so to speak. It may well be that this particular one was not properly handled, and the outcome is one that the NPA would not have preferred. But we must be very careful, because it may well be that there could be lessons learned, and the next ones or the subsequent ones may yield a different result altogether. But from a public perception point of view, I can understand why there would be that perception. But I do not think that we are in a position to generalize, to say just because the first one that was supposed to set the scene was dealt a severe blow by the defense, all other ones may suffer the same fate. I think each case will have to be determined and must be and should be determined on its own merits, the strength of which we do not know at this stage. But I think the NPA would be well advised to make sure that they cross all the T's and dot all the I's. But yes, it is not a good start.
Mr. Majavu, then some of the high-profile cases that have, of course, captured the imagination of South Africa more broadly. The Senzo Meyiwa trial was back in court this week, and, of course, fourth witness and one of Meyiwa's friends, Mthokozisi Thwala, one of the people was in the house on the night that the soccer star was shot and killed. He testified this week and obviously revealed his own order of events as he remembers them. But one of the criticisms that came through here has, of course, been state prosecutor in this trial, George Baloyi. And the defense, of course, seemingly very unhappy at times, saying that the state prosecutor was basically leading this witness to an unacceptable extent in their view. So what did you make of the proceedings and how it all played out?
That's lawfare. Practitioners will try to push the envelope if the other one is sleeping on the job. And I'm saying that metaphorically. If the defense is of the view that the prosecutor is leading beyond what is reasonably acceptable in lawfare, they have a right to be on their feet and object motivate the objection, and the judge would then give a ruling, having afforded the prosecutor an opportunity to respond to that objection. And in some instances, it may well be that the objection may be overruled, or in others, it may be sustained. It should not face any seasoned practitioner. You don't complain about it outside of the court of law. You raise objection there and then. And in my view, I do not think that some criticism may be justified or justifiable against Mr. Baloyi. But if there were to be such criticisms, then as a practitioner, your remedy is to deal with it there and then. The same could easily happen for the defense counsel, by the way, when it is their turn to lead their witnesses. If Mr. Baloyi takes the view that they are leading the witnesses unduly, then he too must stand up and raise his objection and motivate it. It would not be good of him or others to raise it outside the forum before which it is playing itself out.
Now, Ms. Majavu, you've obviously followed this trial from when it began, and if you look at the evidence that has been led so far, starting from the first state witness, I'm curious to hear your thoughts on, for example, the murder scene and how that was actually processed. What did you make so far in terms of the evidence that has been presented before the the Johannesburg High Court? Do you believe that the evidence may have been tampered with in any significant way?
My considered view is that the crime scene was not handled in accordance with the standard operating procedures. In some instances, it was handled in a manner that would contaminate the outcome thereof. So that, I think, was poorly or inelegantly handled. And that may have a direct impact on what flows from them. I mean, in legal parlance, we refer to it as fruit of a poison tree. And any seasoned practitioner would always start at what happened at the crime scene. And if it was contaminated, you latch on to that. We have now only started to hear evidence from direct witnesses who were in the room. And it may well be that as they recount their own recollection of the events as they unfolded, they may materially contradict the testimony of the crime scene experts who were led first. So I foresee a number of problems. I know it's still early days to go, but my sense is that it's not progressing as well as it should, mindful of the amount of time that the state had to investigate this matter. If you ask me, I think the whole case so far is not going very well from the state's point of view. But because it is still early days, we don't know the next witnesses that are going to come, to what extent they might bolster the state's case. It's very difficult in this kind of case to say which way is the wind blowing. But on account of the testimony of the witnesses that we've heard from so far, on my count, I don't think the state is making any significant progress, not at all. Which, in fact, it was even aggravated, in my view, at some point when Mr. Baloyi wanted to also re-clarify issues that he termed inconsistencies by his own witnesses. That is also quite telling, and I'm not surprised that the defense counsel are making a meal of it.
Well, Mr. Majavu, we're out of time. There's so much we didn't touch on, but we'll leave it there, and hopefully we'll speak to you again as these court cases unfold. Zola Majavu is a criminal law expert giving his legal analysis on this week's wrap of some of the court cases that we have seen, and these have, of course, captured the nation's interest. And we'll speak to him, I suppose, later on about some of the others that we didn't get to speak about this morning.